Hi, Jonathan Ginsberg here, and I want to talk to you today about reaffirmation agreements in Chapter 7 bankruptcy. Reaffirmation agreements have really changed quite a bit in the 20-plus years I've been doing this type of work. In the past, when a Chapter 7 debtor wanted to reaffirm a debt, it was a pretty simple process. We'd fill out a 1 or 2 page document, send it back in, and everything was kind of fine. Now it's a lot different. So let me explain, first of all, what a reaffirmation is, and secondly, how it works now. In terms of what it is, when you reaffirm a debt in a Chapter 7, typically it's going to be a secured debt. Could be a house, a car, furniture, jewelry, something like that, where there's actually property that secures the actual debt. In theory, you can reaffirm an unsecured debt, but that's much less common. But when you reaffirm a debt, what you're basically saying is, I want to continue making payments on that debt, and even despite the fact that I'm discharging the debt in bankruptcy, I want to basically renew it, reaffirm it, take it back out of bankruptcy, and treat it as if no bankruptcy had ever been filed. So I want to continue to be personally obligated, because you see, when you have a secured debt and you include it in a bankruptcy, the secured part, the property lien, the claim that the lender has against the actual asset, the house, the car, the furniture, that remains. But your personal liability, your personal promise to pay, that disappears in a Chapter 7 discharge. So, for example, if you file Chapter 7, you've got a car loan, the lien on the car remains, but your personal obligation to pay that debt is gone. It also, the lender, by virtue of the contract, would be able to repossess that car for a variety of reasons, but the main one is that you're not personally obligated anymore. That substantially changes the contract. When you reaffirm a debt, you're basically saying, we're going to, of course, keep the property lien in place, but what we're also going to do is we're going to renew and restate and reaffirm our personal obligation to pay the debt. So the lender is essentially in the same position vis-a-vis state law remedies against you after bankruptcy when you have a reaffirmed debt. So that's what reaffirming is. I always tell to my clients like this, it's as if you're taking this debt out of bankruptcy, treating it as if you've never filed bankruptcy before. And typically when you reaffirm a debt, you do so under the same terms of your contract, although I've had some success in renegotiating the terms of a reaffirmed debt, meaning that sometimes I'm able to get better terms, reduced interest rate, lower payment, and so forth when I reaffirm a debt with a client. So when we reaffirm debt, what generally happens is we notify the creditor we want to reaffirm. They will send us a detailed reaffirmation document, and nowadays it's about 10 pages. And what it basically shows on there is we've got to show, first of all, a bunch of disclosures that we understand, or my client understands what he is paying, the interest rate, the length of the term. Plus, I've got to fill out a form that says that I've looked at this and that I believe my client can afford to reaffirm the debt. I have to show in a budget calculation that there is enough money in the budget. And this, by the way, is why people who file bankruptcy without an attorney have a hard time reaffirming, because they don't understand necessarily how to fill out these reaffirmation agreements. But if we show on our budget in a reaffirmation that there's not enough money to pay the reaffirmed debt, the judge will not approve it. So we've got to have enough money left over in our budget to pay the reaffirmed debt. So we file the reaffirmation agreement, we prepare it, I send it back to the lender signs off on it, then files it. And once it's filed, that reaffirmation becomes permanent within 60 days or the date that the bankruptcy closes, whichever is later. So a minimum of 60 days that you can undo the reaffirmation agreement. So if we decide that the reaffirmation agreement is not in our client's best interest, 25, 30 days in, we can undo it. We can file a form and undo it and eliminate the personal liability. But once that 60 days is over, or the case is closed, then you cannot undo it and you're stuck with it. It's a permanent type of debt. That's why it's so important that when you reaffirm a debt like a car loan or a furniture debt, that you know that you're sure that you can afford to do this. Because if you reaffirm a debt and then find out, 6 or 7 months or a year and a half later that you can't afford it, you got a problem, because there's really not much we can do. At that point, it's a reaffirmed debt, and the lender has all state law remedies. Now, I get a lot of emails, I mean a lot of emails from people who have not reaffirmed mortgage debt and then discover 3, 4, 5, 10 years later that the lender is not reporting to the credit bureaus and that they cannot refinance. And the reason for that is, again, when you do not reaffirm a debt, what happens is you're taking your personal liability out of the picture. So the lender will not report your payments to the bank, or to the credit bureaus rather. So you may be making payments every month on time religiously for 3 or 4 years. You pull your credit report, it will show that this debt to this mortgage lender has been discharged in bankruptcy. And when you go to refinance or to get another loan, your credit will not show that you've made all those payments. So not reaffirming can have some pretty negative repercussions, and there's not a lot you can do about it. People say, well, can I reopen my bankruptcy case? You know, in theory you could, but I see a lot of judges don't want to do that because it's kind of a waste of time for them. And so some judges will not let you reopen a case simply to file a reaffirmation. So I would think long and hard about whether you want to reaffirm, whether you feel you want to put yourself under the personal liability again. But if you don't reaffirm, realize that making those ongoing payments while you'll be able to keep your property, it will not benefit your credit report. So, you know, and sometimes you can't reaffirm because you don't have enough disposable money on paper to do so, but just be aware of the consequences. Again, reaffirmation is something that you and your attorney should really sit down and go over in detail the pros and the cons, why you should, why you shouldn't, so that there's no surprises down the road and you're not one of those people writing a bankruptcy attorney like me saying, you know, my attorney did not advise me to reaffirm and now I'm stuck 3 or 4 years later, I can't get credit for a new loan. So again, reaffirmation is something that really deserves some time that you and your attorney need to spend. I try to talk about it with my clients going in, but at least at the 341 hearing, spend a few minutes afterwards talking about it with your attorney, or with me if I'm your attorney. But again, don't ignore it. And just one final point about that is that there is some law out there, there is some automatic stay law which suggests that if you do not fulfill your obligation, you say you want to reaffirm on the statement of intentions, you do not do so, that the automatic stay could come to an end. So we had this happen in our office recently where a client indicated he wanted to reaffirm a debt, a car loan, but would not ever sign off on the reaffirmation agreement, wouldn't commit to it. And I believe 30 days went by and the lender said, well, you didn't fulfill your intention, and they picked up the car. And they're allowed to do that. So be aware that if you say you want to reaffirm, you got to do it. You can't just say you're going to do it and then do nothing, because again, some lenders, not all, but some lenders will hold your feet to the fire and you could end up losing your property because you did not reaffirm. So again, talk to me, talk to your lawyer about this more, but be aware that it's not a simple concept anymore, not a simple procedure. It does deserve some time and some effort between you and your lawyer to discuss the idea about reaffirming a secured debt in a Chapter 7. I hope that's been helpful. This is Jonathan Ginsberg, and until next time, I'll talk to you soon.